Good morning. My name is Judge Anthony Powell, and welcome to the July 8th, 2021 morning docket of the Kansas Court of Appeals. I'm very pleased to have with me two very distinguished judges, Judge David Bruns, and also one of our recently retired judges. We're very excited to have Judge Steve Leben back with us today. We brought him out of semi-retirement. I guess he's not really retired. I don't think Steve will probably ever fully retire, but we're really glad to have him back and sitting with us on this docket today. We have one case on the docket, and that case is Midwest Crane and Rigging LLC versus the Kansas Corporation Commission and Mike Hamey, case number 122562. And could the court have the appearances of counsel, please, starting with the appellant?
May it please the court, Kurt Brock on behalf of the appellant, Midwest Crane and Rigging LLC.
Thank you.
Your Honor, Brian Fedotin on behalf of the Kansas Corporation Commission.
And Stan Parker, Assistant Attorney General on behalf of Mike Hamey.
Very good. Thank you very much, counsel. We are familiar with the facts of your cases. We've read the briefs, and so you don't have to give us a complete rundown on all the facts. We are acquainted with your arguments. I did want to ask the appellees in this case, since you're both appearing, how do you wish to kind of divide your 15 minutes between you?
Your Honor, I think we've agreed that I will take 10 minutes, assuming we have a total of 15 minutes, that I will take 10 and Mr. Parker will take 5. And if I don't use any of that time, obviously I'll hand it over to him.
Well, depending on how things go, we're not super strict with the time. We try to keep within the time limits to make it fair, but certainly if there are questions and we go over that, we'll have a little leeway there.
Sure.
But I'll basically try to follow that request. Mr. Brack, as the appellant, would you like to reserve any of your time for rebuttal?
Yes, Your Honor. I'd like to reserve 3 minutes, if I may.
All right, Mr. Brack, you may proceed.
May it please the court, Kurt Brock on behalf of the appellant, Midwest Crane and Rigging LLC. Midwest Crane is a small family-owned business that's located in Olathe, Kansas and St. Joseph, Missouri. As its name implies, it's in the crane rental business. It hires union operators to operate its cranes, and primarily they're engaged in construction work in the Kansas City and St. Joseph areas. The facts are generally not in dispute. As far back as 2006, Midwest Crane was involved in litigation with the KCC. The case that gave rise to this case began as a traffic stop of all things and made its way from the KCC to the district court to the Court of Appeals and then subsequently the Supreme Court, where the Supreme Court issued an opinion. This case, the current case, was filed back on July 19, 2018. The defendants in this case, each of them filed a motion to dismiss. Discovery was issued by the plaintiff, but stayed by the court. Judge Tice, who was handling the case at the time, after a long career on the bench, retired, and the case was ultimately reassigned to Judge Mary Christopher, who took over. The district court then granted the motions to dismiss and dismissed the amended petition which had been filed by Midwest Crane. We submit that the issues before you are whether or not Midwest Crane stated a claim for relief against these defendants, and more importantly, whether or not the standards in deciding a motion to dismiss actually mean something and were followed by the district court. We contend they were not. Your standard of review, I think is a good place to start, is a de novo standard of review. And the analysis, I think, begins with a motion to dismiss, and we are all likely familiar with that language. The court is required to accept the facts alleged in the petition as true. The facts are considered in a light most favorable to the plaintiff. And if the facts state a claim, or for that matter, any claim for relief, dismissal is improper. The granting of a motion to dismiss is not by the courts in Kansas. And finally, skepticism is required when a motion is made prior to the parties completing discovery. In this case, Midwest Crane has alleged that it pled a claim of malicious prosecution against both the defendants. Both defendants only challenged the first two elements of a malicious prosecution claim. Those elements are the defendants initiated, continued, or pressured civil procedures against the plaintiff, and the second element, the defendant acted without probable cause. As to the first element, the defendants initiated, continued, or pressured civil procedures against Midwest Crane. It starts with the citation, and we've attached a copy of that to Exhibit B to the brief.
Mr. Brock, can I stop you? Can I stop you there and talk about that citation and the Bloom versus Arnold case? The Bloom versus Arnold case talks about administrative proceedings not qualifying, and then has some language in it saying that generally judicial process needs to start with one of several things. And the one in your reply brief that you've honed in on is summons. And you said that this traffic citation would qualify under the law set out in Bloom versus Arnold because a traffic citation is a summons. But if you look at the traffic citation, which is attached to your amended complaint as Exhibit B, it actually has a notice to appear, not a summons. So I'm wondering, and that's found volume 1, page 127 in the record. So I'm wondering whether your fallback in the reply brief, yes, this should count because it's a summons. I'm wondering if that really works.
Well, I think we may be splitting hairs here because certainly a notice to appear requires a defendant to appear in court, as was a summons would require a defendant to appear in court or answer. So,
but you're already trying to get us to leap over several things. It's a traffic citation issued by the Kansas Highway Patrol, not by anybody who's a party in this case. We have no case ever finding malicious prosecution or abusive process might work for a traffic citation. And the read that you seem to be grasping onto was this summons concept.
That's correct, Your Honor. And the idea here is this started the ball rolling. This was the first of many different events. And again, don't forget, we're talking about initiated, continued, or pressured civil procedures. So there's not only just the issuance or the initiation of it, but there's also continued or pressured civil procedures. And so the point is, even though this is not technically labeled a summons, we would argue that the effect is still the same. It still requires someone to appear in court to answer to a specific allegation, much like a summons.
Can I just be clear on what you say? If I understand it right from your brief, the things you're saying are the initiation of judicial proceedings are the notice of violation on a KCC letterhead and the follow-on administrative proceeding there and the Highway Patrol citation.
Correct.
Okay.
The final issuance was the initiation before the State Corporation Commission by the KCC, which is attached as Exhibit D to the brief. If you look closely at that caption it has something in it that I don't think anybody contends that Midwest Crane actually filed. In the matter of the investigation of Midwest Crane and Rigging LLC of Olathe, Kansas, pursuant, and it goes on. Clearly, that's not something that Midwest Crane initiated. So,
what's your argument around Bloom versus Arnold with respect to that proceeding?
Certainly, it was a administrative proceeding that began, but again, it continued into a civil proceeding and civil procedures that followed. So,
who was the
elements for malicious.
Who was the civil proceeding before?
The civil proceeding eventually was before the district court.
But not until you had filed a pleading in the district court, a petition for judicial review.
Correct.
Okay.
So, case then moved up from the KCC to the district court, then to the Court of Appeals, and eventually to the Supreme Court. The takeaway here is that each step of the way, the KCC claimed that the terms property and the term cargo were interchangeable, were one and the same. And the crane itself, which is permanently affixed to a vehicle, was considered cargo. There was no support for that position. There was no authority for that position, and the KCC cited none. Midwest has certainly alleged, at least in this case, that the defendants initiated, continued, or pressured civil procedures satisfying the first element of a claim for malicious prosecution. The second element, the defendant acted without probable cause. As this court may be aware, in order to be subject to the unified carrier registration, the vehicle must be used principally to transport passengers or cargo. That's a definition straight out of 49 USC 31101. The KCC and the Hamey admitted that Midwest does not transport passengers, so that leaves cargo. Hamey testified that Midwest used its cranes to transport cargo. His testimony that the words cargo and property were the same. Now, oddly, he also testified that his definition of cargo was something that could be easily transported and removed. That seems to beg the question of, is easily remove a crane that's physically attached to a vehicle? The answer to that, of course, is no. It's not easy to physically remove that. So there was no evidence presented that Midwest Crane used its cranes to primarily transport cargo. Midwest testified that they do not transport cargo, and so we contend, based upon the evidence, that the defendants acted without probable cause. The district court, we contend, erred when it failed to accept those facts which were pled by Midwest in its amended petition and erred in dismissing those claims. The next issue we contend was error was that Midwest did plead a claim for abuse of process against the defendants. The defendants in this case only challenged one element. That element was one of the proceedings were not judicial but administrative. Midwest alleged in its petition, paragraph 70, that the defendants utilized administrative, quasi-judicial, and judicial processes against it when it knew that Midwest was not subject to the UCR. Midwest further alleged that the KCC and Hamey knew that Midwest was not subject to the UCR, and they knew that Midwest did not principally transport cargo with its cranes.
Mr. Brock, other than the conclusory allegation that they used judicial process against you, is there some thing that you're claiming was a judicial process related item in the abuse of process suit other than the traffic citation?
Well, the continuation of the everything from the administrative process to the district court to the Court of Appeals to the Supreme Court, those processes, yes. Well,
there was nothing judicial in the administrative process before the KCC, was there?
Well, I think it was quasi-judicial, certainly.
I'm not asking about quasi-judicial. I'm trying to know specifically, because a lot of administrative agency actions are quasi-judicial, but Bloom versus Arnold certainly suggests to me that doesn't get you to an abusive process claim. So I'm trying to be sure I know where you have a judicial process here. And if I'm understanding it right, the only thing you've pointed to prior to the petition for judicial review filed by Midwest Crane is the traffic citation.
That's correct.
Okay.
That's correct. The district court focused on whether the actions of the defendants with regard to the abusive process claim were knowingly illegal. Now, the issue of knowledge, as you are aware, is a question of fact, and it's improper to decide that on a motion to dismiss. Instead of following the law on a motion to dismiss, the district court ruled on the merits, and we believe that the district court erred in dismissing the claim. The final claim was a claim of violation of 42 U.S.C. section 1983 against Mr. Hamey. Midwest had alleged a claim under 1983 against Mr. Hamey. A plaintiff in a 1983 case, as you're aware, must allege a violation of a right secured by the Constitution and laws and must show that deprivation by a person acting under color of state law. Midwest alleged that Mr. Hamey was a director of transportation, was acting under color of state statutes and state regulations. The district court found—
Mr. Brock,
Yes.
Let's go back to the basics on this. Midwest is an LLC, is that correct?
It is.
Does an LLC have rights under the Fifth Amendment of the United States Constitution?
I believe it does, Your Honor.
And can you cite me to a case that says that?
Not currently, but I can certainly try to forward one.
Because it was my understanding that at least when it comes to the self-incrimination, certainly, that business entities do not, that those are personal individual rights. But just so we're clear, you're claiming this on behalf of a business entity.
It is a business entity, correct. And their driver who was stopped, right? I mean, he was the agent.
But the driver isn't a party to this case.
He is not a party to it. He's only a witness, Your Honor.
Okay.
Yeah.
Brack, you have used up your 12 minutes. If you want to.
I'll reserve the rest for rebuttal.
If I can, Judge Powell, ask a couple other
Sure,
questions related to
absolutely.
qualified immunity and statute of limitations on the 1983 claim. So your civil rights section 1983 claim has two defenses that were significant in the briefing. First, on the statute of limitations, you asserted in your reply brief that had not been raised before the district court, but it's raised in both the brief in support of the motion to dismiss of Mr. Hamey and the brief in support of the second motion to dismiss when you had the amended petition. It's the last paragraph of each of those, pages 63 and 197 in the record. Does that in any way change your argument? Is that not sufficient for them to be able to raise that in their brief here on the appeal?
I believe they can raise it in the brief on the appeal, Judge. If I misspoke, I apologize to you and to the court.
Okay, no problem. And then on qualified immunity, you've essentially said, citing a case from 2006 in the Third Circuit, that you have no obligation at a motion to dismiss stage to show that qualified immunity won't apply. The U.S. Supreme Court had a case whose name escapes me at the moment in 2009, 3 years after that case. And there certainly have been a ton of qualified immunity cases decided across the country on a motion to dismiss since then. I'm having trouble figuring out here what your best argument is that the decision, for example, made by the Court of Appeals that got overruled by the Kansas Supreme Court in their case, why that doesn't settle the probable cause question for the purpose of qualified immunity.
I don't believe that the case that we cited, Judge, was the Thomas versus Independence Township case out of the Third Circuit, the 2006 case. And generally, that case held that a plaintiff doesn't have to anticipatorily plead that some defendant is going to assert a claim of qualified immunity. And that's the reason we cited to that. In other words,
they've claimed it here in their motion to dismiss and in the briefing in the trial court. The trial court's addressed it, and I'm still not understanding what the reason is they don't have. The issue is so completely clear cut that they don't have qualified immunity. So if you want to just pitch that, why the issue was so clear cut they don't have qualified immunity.
Well, Your Honor, what we've cited in our brief is that they don't have qualified immunity because, there's two things that we have to show. The defendant's actions violated constitutional rights, number one, and number two, that the right was clearly established. We contend that right was clearly established because if you look at the definitions and even go to Black's Law Dictionary, nobody in their right mind would consider cargo as a self-propelled crane apparatus attached to a vehicle.
Didn't our court struggle with that in the case that got overruled by the Kansas Supreme Court?
In a 2-to-1 decision, you are correct, Judge, that yes.
Right, but I'd hate to say when you say no rational person, whatever, could make that conclusion, it's two of our colleagues, so I really don't think I want to go there.
Well, and I'm not criticizing your colleagues. Please don't take my comments the wrong way. What I am saying is, just in a simplistic look at the definition in the dictionary, no one would say that that is considered cargo. And even by Mr. Hamey's own recognition, his own definition of easily removable, there's no way that would be considered cargo. And so the point here and the takeaway here is that clearly it was a right that was established, and we've alleged in the petition that there were other things that were going on, for example, pulling permits, not allowing permits to be issued, threatening to pull the DOT number of Midwest Crane, which would effectively put it out of business. In essence, retaliation type claims. Those rights certainly are established and are not appropriate by the defendants in this case.
Thank you.
Thank you, Judge.
Thank you, counsel. Mr. Fedotin, since we gave Mr. Baca some extra time, I'm going to give you 13 minutes.
Thank you. May it please the court. Good morning. My name is Brian Fedotin, and I'm appearing on behalf of the Kansas Corporation Commission. This is my first Zoom oral argument, so please, if I cut out or if you're having any trouble hearing me, please let me know. In their brief, Midwest Crane frames the issues as simple ones. Did it sufficiently state a claim for malicious prosecution, and did it sufficiently state a claim for abuse of process? The answer to both questions is no. Midwest Crane's own pleadings demonstrate it can't satisfy the necessary elements of either cause of action. Therefore, the district court's dismissal should be affirmed. The district court correctly concluded that Midwest's petition indicates that Midwest initiated judicial proceedings before the district court and the appellate court. It also correctly found that Midwest's claim is essentially one of malicious defense or malicious appeal by the KCC, neither of which are recognized as causes of action in Kansas. The district court also correctly found the petition clearly indicates the KCC opened administrative proceedings in response to Midwest's request for a hearing. So in other words, the commission was simply a forum to hear Midwest Crane's challenge of the traffic citation.
Can I stop you right there, Mr. Fedotin? Can I stop you right there and just have you educate me a little bit about how this process works?
Okay.
Now, as I understand the underlying litigation as to whether the issue of whether a crane was cargo, that was initiated by a traffic stop by a Kansas Highway Patrol trooper who issued a citation for a failure to register, and then this citation on a lack of, I forget exactly what the term would be, but the citation that they hadn't registered as a carrier, I think is the correct term. Does the Highway Patrol, are they an agent of the commission? Do they act as agents of the commission? How does that process work? I mean, how does the trooper empowered to enforce the Corporation Commission rules and regulations?
Sure. The Highway Patrol is not an agent of the commission, and there's been no authority presented to this court that would suggest that they are. Basically, it's no different than a normal driver being pulled over by the police officers. And unfortunately, I don't know if you've had any experience with that, but I have been dealt with a speeding ticket before. And basically what happens is the officer hands you a ticket, and it gives you the information about which municipal court that you could contact if you wish to either pay the fine or contest it or what have you. And that's essentially what happened here. The Highway Patrol issued a citation, and they said, if you would like to challenge it, here is the information, and you need to request a hearing before the Kansas Corporation Commission. And that's what happened and what it issued.
Okay, I understand the registration part. They appeared in front of the Johnson County District Court. That was issued against the driver. And then we have this notice on this fee or this fine on registering as a motor carrier, I guess. then there's a notice sent by the commission to Midwest Crane saying pay up, right? Did that happen?
Yeah, Your Honor, maybe this will clear it up. There were two separate citations issued to Midwest Crane. One was a state vehicle registration issue. That is the responsibility of the Department of Registration, not the KCC. And the Department of Registration is never been a party to this appeal. That was what was litigated in the Johnson County proceeding, and the Kansas Corporation Commission had no involvement in the Johnson County proceeding. The issue of UCR fees, which is a federal requirement, which is administered by the KCC, that was a separate citation from the one in Johnson County, but it was issued as part of the same stop.
That was issued by the trooper, right?
Correct.
So how does the trooper have the authority to do that? Is that something that the state law authorizes the trooper to do? Is that by agreement of the commission?
It's state law that authorizes a highway patrol officer to stop and pull over somebody who they believe is violating the law. Okay,
so Midwest Crane gets this, in essence, a ticket on this point from the trooper. And then doesn't the commission then later send a notice to Midwest Crane saying pay up?
It sends a notice that says you can pay up, or here's the process for requesting a hearing if you wish to contest the ticket.
What happens if the Midwest Crane had done absolutely nothing?
If they had done nothing, they did not request a hearing and did not pay the fine, then the commission would be charged with enforcing. Basically, it'd be a default. The commission would be charged with enforcing or collecting the penalty, and we could hold another hearing and take disciplinary action for their failure to.
Right. So the argument then that this proceeding was somehow instituted by Midwest Crane just doesn't sound correct to me. This was started by a trooper and then followed up by the commission saying pay this fee. And if Midwest had responded by saying, no, we want to challenge this, we want our right to a hearing, they're responding to the action of the commission in prosecuting this demand for payment of this fee. Isn't that right?
I respectfully disagree. First, it was initiated by the Highway Patrol, which is not a party to this case, and somebody that a separate body that the commission has no authority over. The commission simply sent out a notice, and it was the process was initiated by Midwest Crane saying we wish to challenge this. And even if the court were to find that the commission initiated it, under Bloom, this is all an administrative proceeding, so none of this really triggers.
Right, and that's a separate issue, but I just want to get to the nugget of who started the ball rolling on this and who kept the ball rolling. And the commission isn't just the arbiter here, they're also the prosecutor, right? I mean, it's the lawyers for the commission who are presenting the case to the commission saying Midwest Crane has got to pay these fees, and that ultimately was adjudicated.
The commission's technical staff would serve as a prosecutor at a hearing, but again, that doesn't mean that they initiated it. I mean, under the Midwest Crane's theory of the case, again, for any time anybody was pulled over for a traffic violation, they could sue the courts for doing its job.
Well, the court, though, isn't prosecuting the state. The DA's office is prosecuting the case, but here, the Corporation Commission both acts as adjudicator and as prosecutor, right? I mean, that's common in administrative proceedings,
yes,
right?
It is, and I think that's probably part of the reason that the Bloom decision came out the way it did, because otherwise you would create a situation where agencies are always at risk for being sued for malicious prosecution out of traffic stops.
Mr. Fatoden, I want to explore this relationship with the Highway Patrol just a little bit more. It has been alleged in the petition that the Highway Patrol was acting as an agent of the KCC for this action. In Exhibit C attached to the petition is the notice of violation from the Corporation Commission and the invoice. And in the notice of violation, which comes from the KCC, it says to direct any disputed questions about violation and or hearing requests to the Highway Patrol. And on the invoice, it again says, if you have any questions about the fines, violations, or amounts, contact the Highway Patrol. And that's coming from the KCC and its notice that starts the ball rolling after the traffic stop in terms of Midwest Crane, as you pointed out. Well, at least from the documents attached to the petition, we have a traffic citation to the driver in Exhibit C, or Exhibit B, but then in Exhibit C, we have the notice of violation, which says, if you have any questions, don't contact us, the KCC, call the Highway Patrol. So my question is, are we able to sort all that out on a motion to dismiss?
Yes, Your Honor. I mean, again, not only is the issue of, you have the issue of who initiated this, but you also have the issue of probable cause and, the case.
Well, I understand we have other issues. I'm trying to get to the question. They've alleged the Highway Patrol is your agent, and the district court didn't buy that. Right. But in your notice that started the ball rolling against Midwest Crane for a civil violation, which in your brief, you said, rather than pay the $300 fine for failure to pay the UCR fee, Midwest Crane requested a hearing before the commission. I found that sentence a little strange. It seems to suggest from the KCC's vantage point, even after the Kansas Supreme Court has ruled, you think the better course would have been for Midwest Crane to pay a $300 fine it didn't owe. But I'm just dealing with the question of whether we can say, as a matter of law, on a motion to dismiss, there's no arrangement between the KCC and the Highway Patrol that makes the Highway Patrol your agent. And I'm having trouble doing that as a matter of law, given what's in the notice of violation saying, don't call us, call the Highway Patrol.
Sure, Your Honor. The motion to the dismissal was still proper because, again, even if the Highway Patrol was acting as an agent of the KCC and there's no evidence of that, there's still plenty of evidence that based on their Midwest Crane's own pleading that they can't satisfy the claims. There's still no probable cause, even if they were to have initiated even if it were to be found that the KCC initiated or continued the case, that there's no probable cause, so the malicious prosecution fails. So in that sense, initiation is irrelevant because it's only one of the grounds for the dismissal.
Thank you.
Sure. You've about used up your time, so if you'd like to wrap up, please.
Sure. I just want to point out that the caption of the KCC proceeding, as Midwest stated, does talk about that it's pursuant to the Kansas Highway Patrol issuance of a notice of violation. So again, the KHP, which is not a party to this, started the process, not the KCC, and then it was continued at all phases by Midwest, not the KCC.
Mr. Stoughton, I had a question about the statute of limitations as it affects any KCC defenses.
Sure.
Did the KCC ever raise the statute of limitations in its filings in the district court?
Just so I'm clear, Your Honor, are you talking about the filings at the district court in this or the initial ones back in like 2014?
No, in this case, the claim you made in your appellate brief was that if Midwest Crane wants to start things based on the traffic citation, they can't go there because of the statute of limitations.
Right.
And I see that in Mr. Hamey's motion to dismiss filed in the district court, the statute of limitations was raised. I'm wanting to know whether the KCC ever raised or mentioned in any of its briefing some argument about the statute of limitations.
Sure. Yes, we raised it in response to the amended petition filed in the district court because it was the Midwest Crane did not really make an issue out of that earlier Johnson County citation in the initial petition. On the amended petition, it emphasized that, and so we did not brief it. I'm sorry, we did address it in our response to the amended petition.
Okay, thank you.
Sure.
Counsel, let me make sure I understand this. We're dealing with the violation of a federal statute. Is that correct?
Yes, the UCR fees was a federal requirement. Now Kansas has adopted the UCRs, though.
Well, and that's what I'm trying to figure out is was Midwest charged with a violation of 49 USC 14504A?
I don't have the statute in front of me. I believe that was the violation, the number of the violation of the UCR.
Couldn't any law enforcement agency issue a citation or a notice for a violation of that federal statute if they have reasonable suspicion or probable cause to do so?
I believe so.
I mean, it isn't necessarily just the Kansas Highway Patrol. It could be the sheriff in Cherokee County. It could be the police department in Wichita. It could be a variety of law enforcement.
That's my understanding, Your Honor.
And I assume that you have no agency relationship, any official agreements with any of these law enforcement agencies?
Not that I'm aware of, Your Honor. I certainly hope not. It would further complicate my job. Anyway, just to briefly wrap up, Your Honors, since the commission did not initiate the court proceedings and prevailed at both the district court and court of appeals, the commission had probable cause to defend itself in court. Therefore, the court should affirm the district court's dismissal of Midwest Crane's claims for malicious prosecution and abuse of process. Thank you very much for your time. And I'm available for any other questions you have.
I see none. Thank you, counsel. Thank you very much.
Thank you.
Mr. Parker, we'll hear from you. You have 7 minutes.
Thank you, Your Honor. May it please the court. I am Stan Parker, Assistant Attorney General, and I'm representing Mike Hamey in this case. All 3 claims were asserted against him. I would adopt the arguments the KCC made with respect to the abuse of process and malicious prosecution claims. In addition, on the question of agency, there are certainly no, first of all, the allegation that the Highway Patrol was somehow an agent of Mr. Hamey is both a legal and factual conclusion, which on a motion to dismiss need not be deemed true, unless there are also facts alleged to support that conclusion. And there are no such facts alleged here. There is absolutely nothing alleged to indicate that the Highway Patrol was somehow an agent of Mike Hamey. Beyond that, again, Midwest Crane is the one that initiated the administrative proceedings. Administrative proceedings can't be the basis of malicious prosecution in any event. I'm going to move on to the 1983 claim because that is only against Mr. Hamey. First of all, we argue that there was no actual personal participation in any constitutional violation alleged. That's in the brief. Unless there are questions, I'm not going to spend a lot of time on it. Other than to note that the only allegations in that regard were stated on information and belief, which again is a conclusory allegation, not required to be deemed true unless there are facts alleged to support that conclusion. And there are no such facts alleged in the amended petition. Mr. Hamey is also entitled to qualified immunity, as the district court found. When a defendant asserts qualified immunity, the burden shifts to the plaintiff to establish that the defendant's actions violated their constitutional or statutory rights, and that those rights were so clearly established at the time that anyone in that same position would be well aware of the fact that their conduct would be violating the plaintiff's constitutional rights. There are no...
Did you cite any cases from Kansas appellate courts on that point, or was it just the Kansas federal court or 10th Circuit?
It was federal court and 10th Circuit. I don't believe I could find any in Kansas state courts.
Not arguing with you on that. Just making sure I had that right. Thank you.
Yeah, you are correct. They have not alleged in the amended complaint or amended petition any such clearly established right that was so clearly established that anyone in the same position, that being director of transportation for the KCC, would know that their conduct would violate any such right of the defendant or of the plaintiff. And then finally, the statute of limitations. A 1983 claim is a personal injury tort, which has a 2-year statute in Kansas. Petition was filed July 19 of 2018. So anything more than 2 years prior to that would be barred by the statute. 2 years prior would be July 19, 2016. And none of the conduct alleged by Mr. Hamey occurred subsequent to that date. It was all prior and is therefore would be barred by the statute of limitations. I don't believe the district court actually reached that because the district court decided based on qualified immunity. That's the summary. I'm not going to repeat what I've already put in the briefs. If you have questions, I'd be more than happy to try and answer them.
Thank you very much, counsel. Colleagues, any questions from the panel?
No, sir.
Thank you.
See none. Thank you, Mr. Parker. All right, Mr. Brack, you have 3 minutes.
Thank you, Judge. Judge Powell, you raised the question a moment ago about Exhibit C and the notice of violation, and it was how it was tied to the report, which was the citation and report that was issued by the Kansas Highway Patrol. Exhibit C contains a reference to the roadside examination report, which matches the roadside report number that was set forth in Exhibit A. And so those documents clearly do tie together. We would also note that we had pled that the Kansas Highway Patrol was an agent of the KCC, and I think there is at least some argument here and back and forth between certainly there's a tacit understanding, if not an actual written one. Remember, we didn't do any discovery, we weren't allowed to, but there certainly is some support for the fact of the Kansas Highway Patrol acting on behalf of the KCC, because those documents do tie together.
If that's the case, aren't they also, counsel, if that's the case, aren't they also then acting as an agent for the federal government, since we're talking about a violation of a federal statute?
Yes, they would be.
So the Kansas Highway Patrol is also an agent of the United States of America.
Well, to the extent that they attempt to enforce federal laws or enforce state laws that violate federal law, the answer to that I think would be yes.
So anytime a law enforcement agency is enforcing either state or federal law, they are acting as an agent for either the state or the United States of America.
Well, potentially that could be the case. Again, every case is different, Your Honor, but the idea here is that certainly the Kansas Highway Patrol and the KCC, if you want to dispute one of these citations, you don't knock on the KCC's door, knock on the KHP's door. Well, why is that? There obviously is some sort of understanding between these two entities about who is handling what. And that's our point, is that there is something there that, and of course, we didn't have any discovery to be able to flesh that out because it was decided on a motion to dismiss and discovery was stayed. But certainly there appears to be more than to the relationship than the KCC is letting on. So the final thing I would add is counsel for Mr. Hamey argues that he didn't have any personal involvement in that. That argument fails, as the district court did find that Midwest Crane's allegations were enough to state a claim against Mr. Hamey individually. In other words, that Midwest made a plausible claim against Mr. Hamey. Mr. Hamey did not cross-appeal that decision, so that issue is not before the court. So for all of those reasons, Your Honors, we would ask that the court reverse the decision of the district court and remand the case back to the district court for further proceedings.
Counsel, thank you very much. Any questions from the panel? I see none. Counsel, we thank you very much for your arguments today. They were very helpful. And of course, we will look at this case carefully, and we will render a written opinion as soon as we're able. Thank you very much.
Thank you for your time.
Thank you, Your Honor.